Okay, great to see everybody here. Our fourth and final panel will be focused on the following, which is assessing strategies to delay generic drug entry, and it will be moderated by Professor Scott Hemphill. Professor Hemphill is the Moses H. Grossman Professor of Law at NYU. He is the former Antitrust Bureau Chief of the New York Attorney General and current co-director of the Engelberg Center on Innovation Law and Policy. Professor Hemphill's scholarship on tactics to delay the marketing of inexpensive generic drugs has been widely cited by the US Supreme Court and other courts, including in the recent case of activists. His writing has appeared in leading law reviews and peer-reviewed journals of economics, science, and law, and he has testified before the US Congress about mergers and proposals to incentivize new drug development, among other matters. He is a passionate and exceptional educator. I would know because I've taken 2 classes with him. Voluntarily, that is, voluntarily. With that being said, I'm honored to introduce Professor Hemphill in this final panel.
Hi, everyone. Welcome back. It's a pleasure to get to convene this distinguished group and talk about these important issues. As was mentioned, our topic is strategies to delay generic entry. What we have in mind are generic, typically bioequivalent, for those steeped in the jargon, versions of branded drugs. This is the cheap and cheerful alternative that you get at the pharmacy that's automatically substituted under state law or the practices of insurers. When the generic comes in, as you know, probably most of the folks on this meeting know, the price tends to fall, the average price, certainly the generic's price, and the price that most folks are thereby paying for the drug. Now, as one can imagine, that has a important effect on the innovators' profits, on branded profits. And in response, a variety of strategies have been advanced over the years, individually, and as I think we'll hear, sometimes in combination, to forestall the entry of generics, generating a robust debate about which of these practices are legal, appropriate, beneficial, or their opposite. So we'll be talking about a few of these different strategies, including what's sometimes called a pay-for-delay settlement or reverse payment settlement, where the brand is forestalling generic entry by paying the generic to abandon patent litigation that, had it been successful, might have brought earlier generic entry. We may talk about thickets of patents, something that we typically associate with other industries, but that have arisen in especially biopharmaceuticals, where dozens or hundreds of patents might be brought to bear in ways that some observers find troubling. Sometimes the strategy is as simple as denying access to the samples that a generic needs in order to perform the FDA required tests to get on the market, thereby making life quite difficult for some generics some of the time. So first, we've got a set of strategies that I think we're going to want to be thinking about and evaluating over the next hour. Second, we have a new development that has arisen over the last few years, whereby not just federal antitrust law, but also state law is being brought to bear as an additional tool for thinking about these questions, raising a number of interesting questions of both law and policy. Fortunately, we have an all-star panel to help us untangle this. I'm sure at the end we'll all have clarity and be on the same page about all of these important questions. Let me offer just a brief introduction to our panelists, some or all of whom may be known to y'all. First, Robin Feldman, the Arthur J. Goldberg Distinguished Professor of Law and Director of Center of Innovation, among many other titles at UC Hastings, an expert on the role of IP in technology and innovation, drug patents, pricing, healthcare law, published 4 books. She is a true expert on some of the issues that we'll be talking about today. Second, Jay Lefkowitz, partner at Kirkland and Ellis, one of their leading lights, leading litigation partners, also an adjunct professor at our sibling law school. It's hard to do this on Zoom. I normally just sort of gesture toward north if I were doing this in person. So think of them as north of us at Columbia. Among many other things, as one to major victories in succession at the Supreme Court, thinking about the duty to warn issue and the liability that generic drug companies face under these circumstances. I remember mooting Jay for the first of these two cases, I think, and the sense in the room was, no way is he going to win this. Of course, we were we were completely wrong about that. A very impressive litigator, as I have experienced firsthand on at least one occasion. Sean Nicholson is a professor, director of the Sloan Program, professor in the Department of Policy, Analysis, and Management at Cornell, director of the Sloan Program and Health Administration, a research associate at NBER, the National Bureau of Economic Research. Current research includes investigations into the value of new medical technology and on innovation in pharmaceuticals and biotech, and in thinking about to what degree do consumers kind of hold on, even net of what they pay, to the gains from biomedical research. Finally, Judge William G. Young, judge on the district court for the District Court of Massachusetts, has been on the bench since his confirmation in 1985. Among the relevant experiences for our purposes is he tried the first of these cases. He tried the first of these reverse payment cases, and did, I think, a terrific and super thought-provoking job with the multiple opinions he issued on this that has provided guidance to the rest of us that are trying to figure out to what degree can we hope for courts to evaluate these often extremely complex behaviors in the marketplace. So with that, let me start the questions, and our hope is to leave a little bit of time for student questions depending on and audience questions depending on how far we get. So first, Robin, let me turn to you. When we think about this terrain, these broad set of strategies to delay generic entry, I guess one question is, all right, can you give us a sort of lay of the land here? How big an issue is this? What are the major components as you see them? And I think kind of importantly, since we sometimes see multiple strategies being deployed on the same drug, how do you think about their kind of intersection and combination to the extent they might generate kind of synergistic effects?
To get myself off of mute there. Thank you for the introduction. And I'm thrilled to hear that we're going to have full clarity and have solved all problems by the end of the hour. And in terms of what you were asking, there are two things we know for certain about the pharma industry. And the first is that generics bring prices down. The FDA tells us that a single generic brings the average price of the drug down about 40%. And when you get 4 generics in, prices come down about 80%. So we know if you have generics in the market, that's reducing the drug's price. And then second, delay tactics do pay off. Drug companies don't need to keep a generic competitor off the market forever. Just the delay itself can be worth its weight in gold. Now consider the narcolepsy drug Provigil. The company there paid $300 million to generics to stay off the market. Then it paid $1.2 billion in fines to the FTC and in antitrust cases because of the pay for delay settlement. And then it paid another $69 million settlement to the state of California in a case that's just finishing up now. So all in all, the pay for delay strategy cost the company about $1.6 billion. Now, that sounds really painful, but not so fast. The company executives estimated that delaying the generics brought them an additional $4 billion in sales. So even after paying more than $1 billion in fines and case settlements, the company still netted a tidy sum of more than $2 billion. So these tactics pay. You also don't need a single tactic that's a knockout blow to your competitors. Stringing these life cycle management strategies together is highly effective, and it really is business as usual in the pharmaceutical industry. Just to give you one snapshot, 78% of the drugs associated with new patents are not new drugs coming on the market, they're existing ones. In other words, the patent system in pharma is largely recycling and repurposing existing drugs. Now, recycling old drugs can have value, particularly for some patients at some times. But when a company makes a secondary change to a drug, the R&D investment is generally far less than what's required for the drug's initial development. The company should be able to earn its reward in the market for that. More important, and this really is critical, some of the claims in these piles of patents are of questionable validity. But the more you have, particularly with a biologic drug, the more expensive it can be to challenge them. So in other words, the piles of patents and the piles of delay tactics, all of these can have synergistic effects in which the whole effect is even greater than the sum of the parts. Now, antitrust law has a very hard time handling synergistic effects and tends to look at each individual behavior. I have a piece coming out with Mark Lemley at Stanford that's titled Atomistic Antitrust. And we look at how modern antitrust law struggles to handle the broader picture, even though companies themselves consider all of their activities in these broad life cycle management strategies. My favorite example of the way current law struggles with seeing the full picture comes from last year's Humira decision. The court noted that the company filed a total of 247 patent applications. I'll just pause here to say that is a lot of patent applications. So out of those 247, all of that yielded 132 patents. Again, a lot of patents on a single drug. 90% of those patents were granted more than 12 years after the drug got to market. Now, the court described this as a, quote, batting average of 0.534. Any baseball fans will appreciate that, for about 50%, which the court said was too high to allege bad behavior. So regardless of whether you think a 50% success rate is the right number for finding good behavior, I have my doubts, but there's a more fundamental problem with this type of logic. If you just count up the number of petitions that were granted versus the number of petitions that fails, it entirely misses the point of the possible synergistic effects of all the company's behavior. I like to say that one cannot understand the magnificence and the power of a symphony by counting the individual notes, nor can one understand the full effects of multiple delay strategies without looking at them as a whole and understanding how they work together.
Great, thank you. Sean, let me turn to you. So speaking as an economist here, obviously a topic for the conference as a whole, but also of importance to our panel is this question of balance between ensuring affordable access on the one hand to drugs and maintaining adequate, robust incentives for innovation. I mean, I think that was implicit in Rachel's comments at the end of the previous panel. So I guess, how should we think about this question as it might bear on some of these debates about barriers to generic entry? I guess one input to this question is how much of the value of these new drugs do consumers hold on to? Any thoughts that you might have about how that balancing question bears on the antitrust analysis of evaluating strategies to delay generic entry would also be most welcome. And I guess just put yet one more thing on the table, since it was in Robin's comments, thinking about small molecules versus biologics, is the story different? A lot of our battles have been in small molecules. Of course, we're moving into a world of biologics. Do the same intuitions and battle lines just carry over to the new context, or are there important differences that change the state of play in some important way?
Yeah. No, thanks for inviting me, and Scott, thanks for the introduction and for the great question. I'll start with a little theory, and then I'll quickly get to the empirics that you mentioned on who's capturing the value. So, from a policy perspective, what policymakers are trying to do, and maybe this is obvious to this crowd, is to allow pharmaceutical firms and biotech firms to have an effective market exclusivity length. So I'm using that term as the amount of time from when the FDA approves the drug to when generics actually enter, not when the patent expires, but when generics actually enter. They want that period of time to be sufficiently long so that pharmaceutical firms and biotech firms will invest the hundreds of millions of dollars that it often requires to bring a drug to the market. But they don't want that amount of time to be so long that the pharmaceutical firms are making, quote, excessive profits. So that's kind of the theory. The government is trying to balance that, make it sufficiently profitable, let those profits accrue for sufficiently long that it merits investing the money to get the drug to the market, but not give away the ranch, essentially. I mean, that's a hard thing to titrate, to balance that perfectly. And how is the government doing it? It's by allowing patents, and it's by issuing laws like Hatch-Waxman that regulate the way the generic firms enter it. So, how long is that market exclusivity period? Well, remarkably, it's been pretty stable at an average, year by year of about 12 years. So, and that's an average. Of course, you're going to have drugs that have market exclusivity longer than 12 years and some that are less. But the average has been pretty stable. And most people think, and I think Scott's written on this, it's really kind of two offsetting forces. One is, to Robin's point, you've got the evergreening behavior of pharmaceutical firms of patenting like crazy, and they would argue that it's justified. And then you have very aggressive litigation on the part of generic firms because the incentives of being the first, getting the market exclusivity on the generic side is really strong. So those two offsetting forces, those forces have tended to offset one another and keep that market exclusivity at about 12 years. Now, that doesn't mean that 12 is optimal. That just means that it's been pretty stable. So to sort of look at the optimal, I mean, I can think of 4, I think, fairly well done studies that look at how much of the value that the drug brings to society, how much of that value in terms of health gain is captured by the consumer patient and how much is captured by the pharma firms. And they're kind of on opposite ends of the spectrum. So HIV, AIDS, and statins, the studies show that a majority of the value is captured by the consumer, as Scott said, net of what they're paying. So and it's not even close in those two examples, according to the studies. About 90% or 80% of the value accrued to the consumer. And then you've got a couple of other examples, one of which I was involved in, myeloma, multiple myeloma and colon cancer, where the pharma firms, at least when the patents were in place, were capturing almost all of the value. Now, the story would be that when those patents expire, the consumers might then capture the value, but at least in that sort of first 15 years, the pharma firms were pricing the products to extract most of that value. I'll just finish with, to your biosimilar, Congress in 2009 tried to think very carefully about the right balance for biosimilars. And they decided to make the minimum market exclusivity 12 years. So obviously the average is going to be larger than that, in part because the patents are probably easier to work around if you're a biologic company. In practice, it's not until the last couple of years that we've seen substantial biosimilar entry in the U.S. and prices coming down. So it's taken about 10 years from the 2009 law, I think, for everybody to sort of understand how the biosimilar patent litigation is going to work. So I would say, even though there haven't been a lot of studies, that most of that value is being captured by industry on the biosimilar side.
Great, thanks. Just picking up on one of the things you said at the end, I do wonder whether ease of avoidance has turned out to be higher in the biosimilar context than it was in the small molecule. That's not me, is it? I don't think so. Let me turn to Jay. So, a lot of cases, a lot of activity in this space, not just reverse payments, but we've heard of a bunch of areas too. I'm wondering, from your perspective, what are the main issues that you see here that are being litigated today? Are there trends or outcomes that have surprised you or that seem to be headed in the right or wrong direction? I think you might be. You're not Zoom muted, but you might be otherwise muted. I can hear you now. Great.
Can you hear me now?
Yes, great. Thank you.
So, look, thank you, and thanks for the introduction. I think that activists has basically set forth a few very clear guidelines and left an awful lot unclear. And so judges like Judge Young have to figure it out on the fly. And we don't have right now that many cases being litigated. In fact, very few patent settlements, according to the FTC's last report, actually on paper violate activists. They only identified 3 settlements out of 226 in their last report that raised any types of trouble at all. And they weren't the kinds of lump sum payments that we used to deal with. But we are now seeing a lot of litigation on other related issues, settlements that have exclusive licenses, settlements that have accelerator clauses, most favored nations clauses. The brand will give 3 or 4 or 5 different generic part of its authorized generic supply. And I think the wave that we're in right now are all of those types of cases. And yet they still present the same sets of issues in theory that activists have. And the real issue is $1 doesn't necessarily mean the same to a generic or to a brand. If you and I are having a dispute over $100 and we decide to settle for $80, we both know what that $80 is worth. And we might settle for 80 because I might think I can't collect the 100, and you might think you might not keep the 100, so maybe we'll settle for 80. But when you're settling a patent case and the patent has 10 or 15 years to go, and you're litigating today, you have to pick some entry date. And any particular entry date is just as easy to be seen as a delayed entry as it is to be seen as an early entry, because it's in the eye of the beholder. And the time value of that period of exclusivity is obviously worth much more to the brand than it is to the generic that's simply going to get 180 days of exclusivity, or really co-exclusivity with the brand, and then the market's going to go open up. And so sometimes other things have to be taken into account in order for them to reach a settlement. And we all want settlements, because if there is no settlement, then the brand monopoly persists until the end of the patent term. And so what judges like Judge Young have to do is they have to look at the ultimate questions, which are often questions of causation. And where we're seeing right now lots of questions in these litigations is, on the one hand, we don't want to relitigate the patent case in the antitrust case. On the other hand, patent issues are obviously important. If you have a generic and a brand suing each other, and the generic knows that 3 other generics have lost that same invalidity case to the brand, well, you can understand why the generic's going to take almost anything it can get in a settlement. Or if the generic has some problems with the FDA and it knows it can't get a drug approval, that's another causation issue. So we're seeing a lot of the wrinkles coming out of the activist decision. And of course, we're now also starting to see some more aggressive FTC enforcement. They just filed a lawsuit a few weeks ago against one of my clients in a case that wasn't even a typical reverse payment situation. And so I think we're going to see a lot of regulatory activity and a lot of private litigation in the coming years on what I would say are the margins of the activist decision.
Great, thanks. Judge Young, let me turn to you. Reactions? Reactions to what you've heard so far? I could have just said question mark. Please proceed. As you think about this, one question I want to ask you, either now or as a follow-up, is what do you make of trying to deal with these complex issues in a courtroom, staffed by a journalist judge with lay, typically with lay jurors if it's a private damages case?
Well, that of course is the basic challenge, and it's a very worthwhile challenge. for the justice system. So let me speak directly to it. What do I make of it? You sort out the issues as best you can. You depend upon competent counsel and an adversary presentation so that they may be presented to a jury, and you accurately instruct that jury to reach out for justice. These are extraordinarily complex economic and policy issues. One of the desirable things I think about the activist decision, and you say, and thank you, my case is one of the first to go to trial. Well, it's very interesting when the law that you are applying is an opinion of the Supreme Court. You don't have various, even federal circuit nuances, and in the antitrust area, you don't have various circuits of different degrees of persuasion. You've got the Supreme Court. And of course, you ask yourself, Mother of God, what do they want us to do here? What were they thinking of? And I won't say that Nexium was a great, well, I started out saying I didn't try this case very well, but I did try it fairly. Well, part of that was I didn't even understand the case until we got going. I had made rulings on summary judgment. Those rulings were wrong. They were net just how the jury came out, but they were wrong. So I listen to those who are skilled, far more skilled than I, and I'm making notes here as we go and thinking to myself, well, these really are the issues. The reverse payment, if we can talk about it, Jay has already very skillfully laid out, that doesn't need to be monetary. It's pretty clear that monetary, you're never going to see that, or you're rarely going to see that. It's going to be far more complex than that. If I looked at the verdict slip I gave the jury, imagine the jury being asked this question. Was AstraZeneca's Nexium settlement with Ranbaxy unreasonably anti-competitive? That is, did the anti-competitive effects of that settlement outweigh any pro-competitive justifications? Answer, no, yes. Well, that really boils it down, doesn't it? People could go on a long time for that. One thing, here's a takeaway though. As a sitting judicial officer, and this I would state very strongly, and it's delay. There is too much delay in the litigation of these cases. The delay that's been talked about is delay pre-litigation. But once the complaint has been filed, there is too much delay. That's on us. I take the position that these cases should go to trial no later than 13 months after the complaint is filed. Frequently, you will find in these type of cases that the parties want a preliminary injunction. I always find that interesting because under Rule 65A, you can, of the rules of civil procedure, you can collapse a preliminary injunction with trial on the merits. I try to do that routinely. That causes everyone to tear their hair and focus on the real issues. Now, I'm biased as a sitting judge. I'm biased in favor of our dispute resolution system, and I stand to be challenged on it. But I'm here to take the position that we can handle these complex issues, and we can handle them in a timely fashion. Timely for me is about a year, year and a half.
All right, Judge, let me follow up on a little bit of that. So first, I just want to mention, as to the jury questions, the verdict questions that you were reading from, I put that on the, I do a little bit of PowerPoint in my antitrust class, and I show that every year. And I just want, just for people who don't know, what Judge Young just did was greatly simplify the series of questions that was offered. And to plug into Jay's comment about causation, one of the many aspects that makes this case so interesting is that the jury basically said, roughly speaking, the conduct was unreasonable, that there was that the payment to induce a delay was unreasonable. So, defendant's bad, defendant's bad, defendant's bad across the first 3 or 4 questions. And then they ask, okay, but for this conduct, would you have gotten an entry date before the entry date that occurred? The answer to that, jury said, was no, right? And so then you're left trying to figure out, okay, what were they thinking? And that was part of what some of the post verdict, briefing and opinion writing got at. So where I want to go though is to ask, I'm staring at the last paragraph of Activist, where Justice Breyer says, I think somewhat hopefully, as in other areas of law, trial courts can structure antitrust litigation so as to avoid all kinds of problems, including, I think, litigating a patent case inside of an antitrust case. And I guess what I just want to ask you to reflect on is, again, as someone who has to then interpret what the Supreme Court said, which is basically, it's just the rule of reason. District courts can figure this out on their own. Just work out your own procedure. He seems to be suggesting, right? You can engage in shortcuts. You've got a lot of flexibility. Go for it. How do you think about receiving a kind of general instruction like that? This is not uncommon in antitrust cases, by the way, right? For those who do antitrust, after Legion, the Supreme Court basically said, we're going from per se liability to the rule of reason. District courts, go put some meat on these bones that we've offered you. Just do your best to structure and come to the truth in whatever order you think makes sense. Do you find that liberating? Do you find that frustrating? I'm just curious, what do you make of a pronouncement like this when you're then faced with this sprawling, complicated case that you've got to boil down in a way that jurors will be able to make sense of?
The short answer is I find it liberating. The discharge of that duty is daunting because it presumes a very high degree, or at least in my poor case, and that I'm not modest, but it presumes a very high degree of economic knowledge. And I realize, I continue to realize in that area and others, that I do not have the sophisticated economics background that many others do. I am an advocate of the adversary system. One fortunate aspect of these type of cases, because the stakes are very high, is that they attract outstanding advocates across the board, and that is delightful. So you learn a great deal.
Jay, let me turn to you. I mean, as we've already sort of mentioned, you've litigated a lot of these reverse payment cases, including Nexium, right? You were central in the Nexium case that Judge Young was talking about.
And very disappointed after that summary judgment ruling. Let me be clear, very despondent.
As you know, Jay, it was wrong. It just took me about 8 days into the trial to figure out why it was wrong.
And you were very candid about it. You were very candid.
Where do you see the causation discussion ending up? Right, you mentioned that earlier as kind of one of the cutting edge issues here. Nexium is an example. Sure. I take it. Go ahead.
Yeah, I mean, look, the Supreme Court, I think, at least Justice Breyer, I think was trying to strike a middle ground. If you remember, the companies went into that case saying, scope of the patent, as long as we have a patent, we can do absolutely anything to exploit our patent. It doesn't matter. That was one extreme. The other extreme was the government position, which was we want essentially per se liability. And the court was very clear, and it's hard to always understand. I've probably read that decision literally 1,000 times, and I glean different things every time I read it. But I think the author was trying to strike some kind of middle ground and then give it to trial judges to do this. What happens, largely because of the billions of dollars in liability, and these are treble damage cases, cases involving a drug like Nexium have such astronomical value that the issue tends to collapse in the first instance on the question of, is it a large and unexplained payment? Because that's the threshold question. But you can have a large and unexplained payment, although unexplained and unjustified don't necessarily mean the same thing in the context of that opinion. But then the question is, okay, so if you have a large and unexplained payment, that doesn't actually mean you have liability, at least according to the Supreme Court rule. I think there are a lot of folks out there, I think the FTC would like to take the position that that is de facto liability. And we have one case right now in the appellate court that's going to tee up that specific issue. But the real, if you look at the rule of reason, that just then shifts the burden. And at that point, you have to look at pro-competitive benefits and justifications. And then you still have to look at least restrictive alternative. Was there some other way to achieve these benefits? The problem is, I think the companies have a hard time staying in the game as long as AstraZeneca and Ranbaxy stayed in Nexium because of the overwhelming potential exposure. So not that many of these cases get litigated. I've had one other case that's been litigated and then it's settled prior to the jury making a decision. That was one of the provisional cases. And then there was the Nexium case. Every other case has settled. I think as we get some more ground rules from some of the appellate courts about how you actually conduct the rule of reason analysis, it will breathe more life into the fundamental question, which is actually causation. What would have happened in a but-for world? And then I think you'll see the law start to percolate a little bit more.
So Robin, let me turn to you, kind of away from doctrine and toward kind of the underlying empirics here. You know, we've already heard mention of FTC studies about frequency and how frequency has fallen over time. There's also an FTC study estimating the costs from settlement, which I think they put at maybe $3.5 billion a year. Is it from memory? I might be off by a bit. Maybe lower what some of us would have expected. You know, we've talked about individual drugs like Nexium, where, you know, on a $3 billion, whatever it is, a year drug, a year of delay might be associated with a consumer harm that's also, you know, north of $1 billion. So we could get a number that gets up pretty fast depending on how we cut the data. How should we think about the empirics here, the size of the potential issue?
So you're right about the Federal Trade Commission study. It was more than a decade ago. They published a study, a report on pay for delay, and they estimated that pay for delay settlements cost American consumers $3.5 billion a year. And that number has been cited by everyone since. There's a lot of information that's still hidden, but there's much more public information about pharma pricing and lawsuit settlements available today than there was a decade ago. And like you, Scott, I've thought for a long time that the $3.5 billion figure was not just old, but off. So I set out to calculate an updated cost. And there are different ways one can measure these things. I wanted to be as fair as possible. So I used 6 different sets of calculations using different kinds of approaches that you can find both in the literature that made sense. And all 6 methodologies yielded results that were much higher than the old FTC figure. So rather than the $3.5 billion a year that was estimated in 2010, the lowest result from the 6 methods that I used yielded an updated cost of roughly $26 billion a year. And the others were much higher. It tops out at about $169 billion. So to put this in perspective, even the lower end figure is 7 times the old FTC figure. And as the basis for all of those calculations, I used 16 pay-for-delay deals in which there's sufficient public information available. I looked at list price, I looked at out-of-pocket costs, I looked at overall Medicare costs. I sliced and diced this thing 6 ways from Sunday. But the point is simply that the cost of these deals for society is much greater than anyone has thought. And it's worth thinking about those impacts.
Great, thanks.
Could I ask a
Sean.
question?
Oh, yeah, Judge.
Professor Feldman, and
Yes.
I'm going back to your first presentation, which I found so helpful. I understand your concern about what you call thickets of patents, but of course, it is our policy to give these limited patent monopolies, and we have a procedure for granting them. I guess if we were in a case where that argument was made in an antitrust context, I would say uninformed, and now I put to you the question, I would say, but so what? The patent office has given them these patents. Where does the liability lie?
So if we had confidence that everything that issues out of the patent office is of good value, that might be a different story. Now, legally, there is a presumption of value, but empirically, if you look at how often patents fall, particularly the secondary patents, you will find that the value of the patents coming out of the patent office is not so great. That should give you pause when you see a huge number of patents being thrown at a particular drug in a way that raises the cost for any individual generic to come on the market. It really, you know, if you break down what is in these patents, it's not an inspiring vision often. If you look at what the portfolio is.
Have you got, you see how simplistic I am, and I say this with enormous respect. Have you got any judge who has expressed that view? I'd be interested. I mean, that judge is saying, well, we've got a patent office, but you know, they make a lot of mistakes, and look at what they're doing with their patents. I'm interested in your argument. Where's the authority?
Yeah, Judge, I mean, I'm gonna let Professor Feldman respond. I just want to add another element here, which is even if that were granted, and a lot of people don't grant that, of course, but even if it were granted, there's a second front that's opened, which is a duly issued patent might not be infringed by a generic product or an alleged infringer. And so even if you thought that they were all valid patents, you might still be worried that a plaintiff would, you know, misuse them, would engage in vexatious or, you know, or knowingly frivolous litigation in order to throw sand in the gears. So the fact that you have a duly issued property right, you know, doesn't tell you whether it's pertinent or not in itself to a generic product. And on these secondary patents, it's often a question of infringement. Like, okay, maybe I grant that the patent is valid, but you know, they've used some other strategy to come to market that isn't implicated by the patent. And especially as to these patents that issue long after the therapy has entered the market, a suspicion arises that because that therapy is prior art, maybe the patent that is filed, it's applied for after the therapy reached the market, isn't essential to practicing the therapy.
I'm familiar with patent misuse, and I know it's pompous when I just say that, but I am.
But I don't mean to make a misuse argument here.
It's a little different. This argument's a little different. This is the thickets of patents argument that I'm asking about.
And I mean to be addressing thickets of patents, a piece of the puzzle, which is you could have 100 patents, 60 of which kind of have to do with your drug, but aren't actually practiced by the drug. And so if someone is trying to offer a very close version of the drug, they too might not be using the technology as to these patents that are valid and yet not infringed. And that could be troubling for reasons that don't need to implicate misuse. Robin, you were actually in the
Sure.
dress too, but
Although
jumped in.
you have a wonderful response there. In terms of an interesting piece of authority, the state law that just passed in California, I believe specifically says that that the court should not presume that the patents, something about the patents are valid as a reason to say that the behavior is appropriate. I'll have to look at exactly what the language is, but they're addressing exactly the question that you're thinking about. That's really
super interesting.
yeah, it's very interesting. And I think I'm not sure whether Oregon's has some similar language, but that's part of what the states are beginning to look at because they're hitting their head against that issue. But if you step back and you think about it, not as much from the cases that have actually gone all the way through, I think there may be some precedent within that as well for you. But also in terms of what's practical is if I've got a big bag of weapons, I can just keep throwing those until one of them sticks. And frankly, I don't even need 50% of them to stick. I only need as a patent holder one, because you only have to have one claim standing at the end to be able to block that generic. So it's in my interest to have a huge bag and just keep throwing and hoping something's going to last there. That's not really a good way to run a patent system, in my view, or a competition system.
So let me get Sean in here with comments, and then I want to turn to Jay, since the California law was raised, and among other things, something that would reverse a statutory presumption of validity of a patent seems like the kind of thing that Jay might want to weigh in on. So let me get Sean, and then let me get Jay.
Yeah, and I'll be brief. I just want to add my sympathies to the judges and juries in these reverse settlement cases, because I think it's a difficult issue. And I think just to sort of explain why, I mean, there are some situations, I think, where without a reverse payment, the generic firm and the branded firm are not going to be able to come to an agreement on an entry date. So just imagine that the branded firm thinks there's a 95% probability that if the patent or patents are fully litigated, they're going to prevail. It's going to be proven valid. But just that 5% probability of seeing their potentially multi-billion dollars of profits disappear is going to get them willing to pay substantially. And pay can mean, allowing an earlier entry date than they otherwise would, and, adding some sort of compensation. So, but that, how do you figure that out as you can't just kind of, this is just not an obvious thing of measuring risk aversion. That's not something judges and juries are sort of used to doing. So I think there are situations where reverse payments can be merited, but I sympathize with trying to figure out when that's appropriate and when it isn't.
Jay.
Yeah, so look, I think Robin is correct in terms of characterizing what the California statute does. It does a variety of things that are very interesting. And, just to be candid about this, I've challenged the constitutionality of the statute. We're waiting for a decision from the judge. It raises serious questions of federal preemption because it does take a presumption of patent enforcement that comes from Congress, and it flips that burden, actually. It also says that an exclusive license, just an exclusive license, is presumptively unlawful, even though Congress has said in Section 361 of the Patent Act that you have an unqualified right to have an exclusive license. But I actually think, as interesting as the preemption tension is in the California statute, the bigger problem with the California statute is that it purports to hold conduct that takes place entirely outside the state of California unlawful. It would be one thing, we're all familiar with California, for example, having environmental laws that impact the auto industry, and they can say, we have our own CAFE standards. You can't sell a car in California that doesn't have certain emissions. But they couldn't very well say that a Michigan manufacturer couldn't sell an automobile to a New Yorker without those emissions, or it would violate California law. And yet, what California's law would do is it would tell two companies who are not California citizens who are entering into a settlement in a case that's pending before Judge Young in Boston, that settlement, just the settlement itself, violates California law. And I think if this case gets litigated in much the same way that a recent case that we litigated in challenging a Maryland law gets litigated, it's likely to be found invalid. And it's not that California doesn't have enormous antitrust tools. We know, for example, that when state antitrust law is substantively the same as federal law, then the extraterritorial doctrine may well give way based on an implicit understanding that the Sherman Act was intended to allow states to regulate interstate commerce. But the problem is when a state tries to project its power and regulate an economic transaction entirely outside of its boundaries, then it runs up against the Commerce Clause. And so I think what we're seeing in California, in Oregon, there are literally 5 or 6 states that just in the last 3 weeks have started to explore different types of laws, whether they're going after drug pricing in particular or drug settlements. I think many of them are in jeopardy, both because of preemption considerations and Commerce Clause considerations.
So I'm going to turn to Robin in just a second, but I think we have a CLE announcement before I do that.
Yeah, thank you, Professor Hemphill. All right, everybody, last CLE code of the day, but I promise it won't be the last you see of me. So the CLE code for panel 4 is biology, B-I-O-L-O-G-Y, biology. For those of you who are just joining us for this panel, you should have an attestation form from Michael Weinberg in your email. If you don't, you can still find the form on the events Eventbrite page in the download section. Please make sure to record the code there, as well as making sure that your Zoom username matches the name that will appear on the form. That's how we verify you. Again, the code is biology. That's for panel 4. One last note is that shortly after the close of the symposium, we will be sending out a Google form to the email that you use to register to the Eventbrite page. That'll allow you to upload your attestation form so we can get you your CLE credits. All right, so one last time, CLE code, panel 4, biology. Pardon the interruption, Professor Hemphill, back to you.
Okay, thank you. So Robin, you've testified in favor of arming states with new tools. Why do they need them? Why isn't the current setup enough from your perspective?
Sure. And before I answer that directly, I pulled up the California law, which is
just don't say biology again. Sorry.
I promise not to say biology. I definitely won't.
Sorry, Kevin.
But just to clarify, in what the California bill says, it does say that as the parties are trying to defend their behavior, the fact finder shall not presume that any patent is enforceable and infringed by the term for the non-reference drug filer in the absence of a final adjudication binding on the filer of those issues. In other words, when you're trying to think about the different parties' behavior and what you're doing, don't presume, unless you have a finding on that this is enforceable and is infringed in this circumstance. So Judge, those are the types of concerns that I was talking about. In terms of what do the states need, and whether we, not just the states, what does the law need, whether we need any more, I would really say the following. The activist case opened the door to antitrust liability in cases of pay for delay, but the legal system just keeps banging its head on the door jamb. In particular, there seem to be difficulties defining each of the terms, pay and for and delay. And we also know from the Federal Trade Commission reports that there have been roughly 1,100 settlements between brands and generics in 7 years. The vast majority of those involve an agreement by the brand, by the generic to stay out of the market for some period of time. We also know that the number of settlements between brands and generics each year has more than doubled across that time. And there are, as Jay mentioned, some troubling signs about anti-competitive aspects of these agreements. So in the most recent year, for example, 76% of the settlements between brands and generics contained some form of acceleration clause. Acceleration clauses can discourage other generic companies from entering because other potential generics know if they enter, they're going to face immediate entry from the generic who settled. So it's a way a brand company can get additional bang for the buck. You settle with one generic and then you discourage others from entering. And then in hints of other anti-competitive aspects of the deals, if you look at the most recent FTC reported year, 90% of the settlements involve the generic receiving rights to patents not subject to any litigation between the parties. Rights like those could easily be the vehicle for transferring value or sharing markets. Now, the bottom line is that there's good reason to believe that activists did not solve the pay for delay problems and that additional clarification is needed, regardless of whether you think California, some people think California gave up too much with the exceptions it allowed, and others think the legislation is too strong. Jay, I know you think that, but regardless of one's perspective, there's a lot of additional work that remains to be done in pay for delay. We really haven't solved it.
So thank you. Let me get a reaction from Sean on a question and then give Judge Young the last word. Sean, one of the questions that comes up, and you could imagine it coming up in reverse payments or in other contexts where we're concerned about delayed generic entry, is where are the purchasers in all of this? And I don't mean individual cash purchasers who have no insurance and find themselves paying, some extremely high price at the pharmacy, but payers, PBMs, who presumably have some power to insist on perhaps particular prices or particular terms of dealing, as a condition for being put on a formulary. One question that sometimes arises is, couldn't the PBMs engage in some kind of self-help to protect themselves against, entry delaying conduct? Is this a feasible alternative? Is this pie in the sky? How do we think about it?
Yeah, I mean, I think so. The pharmacy benefit managers, who are the agents for the end payers, I mean, I think what they are doing and can continue to do is be amazingly effective at shifting market share from the branded drug to the generic drugs as soon as entry has occurred. So, now it's 95+% of market share is going to shift very quickly. And so, but that's just kind of what's known by the players ahead of time. But I really don't think the PBMs can do much more than that. Imagine that a PBM becomes convinced that a branded firm is engaging in inappropriate activities to delay generic entry. The PBM has the power to say, we're going to move that drug to the fourth tier, and it's going to become very expensive in the eyes of the patient, and we're going to stick it to the pharmaceutical firm. But that's really harming the health of the enrollees. And so I would see that as not being a strategy that would be effective for the customers that they're supposed to be looking out for.
Okay, great. Judge Young, some final reactions to what you've heard here?
Well, I'll be very brief. I hope this has been recorded because aside from me, what a marvelous grouping of people who truly care and are raising profound issues, both economic and policy issues in our healthcare field. These are matters in which the Federal Trade Commission, the Congress, and the courts, as well as the Patent Office, share responsibilities for reaching out for justice. I have no answers beyond seeking to discharge my duty with respect to a particular case in controversy, but it is fascinating.
Well, I'm not going to try to build on that other than to say, thank you to the judge and to all of our panelists for a terrific discussion. I really appreciate it.
Thank you.
Welcome. Thanks.
All right, I will keep my closing ceremony statements brief, but thank you, Professor Hemphill, and all the moderators on this panel, and all the moderators for all the moderators and panelists for throughout the symposium. Truly, truly appreciate it. You guys were incredible, incredibly rich conversations. You know, I was lucky enough to be in a class with both Professor Hemphill in law school and Professor Sean Nicholson in undergrad, so this has been particularly fun for me. But anyway, yes, again, thank you to all the panels and moderators. I also want to give some shout outs to Christopher Morton and Michael Weinberg at the Engelberg Center for helping us students guide this conference through. Shout out to Rachel Gallagher and Taylor Peterson for being like assistants for me as a man behind the curtain situation. Shout out to Josh Lynn and Haley Sanders for the wonderful graphics you've been seeing. Yeah, and thank you so much for attending. I could talk about CLEs again ad nauseum, but I think I've said my piece more than enough. If you have any questions regarding the CLE process, again, you can email me, Kevin Chow, at kq364@nyu.edu. And with that, if there are no more issues, thank you again so much. This has been really fun and enlightening. Take care. Have a good one, everyone.